Welcome everyone to our webinar on Advertising 101, Social Media Influencers and the Law. My name is Gemma Abbey and I'm one of the practice leaders in LegalVision's Dispute Resolution and Regulatory team. I'm joined today by my colleague Amelia Bowringstone, who is a senior lawyer in our Dispute Resolution and Regulatory team. We'd like to start today with an acknowledgement of country. LegalVision acknowledges and pays respect to the past, present and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which of those you are joining us today.
Before we begin, just a couple of quick housekeeping items. You'll be emailed a copy of this webinar recording after the webinar. Please submit any questions you have throughout the webinar in the chat box, and we'd be grateful if you could please complete the survey sent to you after this webinar. So today we'll be discussing misleading and deceptive conduct in advertising, avoiding misleading and deceptive conduct, advertising financial products and services, the advertising code of ethics, promoting your business using customer reviews, offering incentives for customer reviews, influencers and social media advertising, and using formal agreements. As I mentioned, at the end of the webinar, we'll be answering some of your questions. So please submit these questions throughout the webinar through the chat function, and we'll answer them at the end. We'll also be sharing a special offer for our attendees today. Now I'll hand over to Gemma, who will speak about misleading and deceptive conduct in advertising.
Thanks, Amelia. So the first topic we're going to talk about today is misleading and deceptive conduct claims in advertising. Businesses these days have many different mediums through which they can advertise their products, services and promotions. In general, businesses must not engage in misleading and deceptive conduct, as this is an offence under Section 18 of the Australian Consumer Law. So Section 18 provides that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or is likely to mislead or deceive. Section 29 of the Australian Consumer Law goes further and relates to false or misleading representations in connection with the promotion by any means of the supply of goods or services. So this overriding obligation on businesses to comply with the law and not engage in this type of conduct extends to all forms of advertising. So what would amount to misleading and deceptive conduct in advertising? Misleading and deceptive conduct can relate to false and misleading statements about a product, service, or promotion. For example, claims about the quality, value, price, age, or benefits of goods or services, or any associated guarantee or warranty, which are untrue or likely to mislead consumers. If the overall impression of the advert created is false or inaccurate, this will amount to misleading and deceptive conduct. This is so even if it is done unintentionally. Considering this, we're now going to go over some of the tips to help businesses comply with the law. So businesses should always ensure that all statements accurately and correctly describe the product, service, or promotion. You should always use simple language that is easily understood by consumers. Absolute statements should be avoided unless they're based on recent data or facts. For example, a claim that a cleaning product kills 100% of germs would be difficult to substantiate and would be an absolute statement and something we would recommend avoiding. Use of statistics and substantiation should be included in the advert to support any claims being made. For example, based on an analysis of 100 customer reviews, 8 out of 10 customers say they use this product daily. If you decide to use photographs and images or videos, these should not contradict, detract from, or reduce the prominence of any warnings, disclaimers, or qualifications. Businesses should consider the appropriateness of using social media channels for advertising if content limitations means there is insufficient space to provide balanced information. So for example, your full advert on a billboard might have the right impression, but once you try and cut that content down to social media, it might then change the impression to consumers. Businesses should always make use of disclaimers. Disclaimers should be used to set out key terms and conditions, eligibility criteria, and exclusions. Warnings, disclaimers and qualifications should be able to be easily read by consumers, so avoid using any fine print. Disclaimers should be appropriate for the type of advertisement. Some of the common pitfalls that we see with videos, in particular, TikTok has overlays, and these can obscure disclaimers depending on the positioning. For YouTube, there is an ability for videos to pop out from any static posts and words, which means that it's safer to have these disclaimers on the video itself, so it does not create a misleading impression when it's viewed in isolation. And finally, consumers should not need to go to another website or another page of a website to correct a misleading impression. So for example, if the landing page of a website contains misleading information, but this is corrected in another tab on the website, this will not be sufficient. Moving on to financial products, we wanted to briefly highlight there are some additional rules when it comes to advertising financial products. This is because ASIC has identified that consumers are heavily influenced by advertisements when making financial decisions and seeking financial advice. ASIC has published lengthy regulations in relation to advertising financial products, which we're not going to go through for the purposes of today. However, we would highlight that some of the key legal considerations include that these advertisements should give a balanced message about the returns, features, benefits, and risks associated with the product. So not highlighting all the benefits and hiding all the risks. They must comply with the Corporations Act, and in particular by identifying the product issuer. For example, insurance may be sold by a bank, but it is in fact issued by an insurance underwriter. And also by setting out the location of product disclosure statements and target market determinations. Those of you selling financial products will be very familiar with those. Further, where advertising includes general advice in relation to a product, for example, statements about why a product is great, an inclusion of a general advice warning will likely need to be included. Now that we have covered misleading and deceptive conduct, we will move on to the Advertising Code of Ethics. Over to you, Amelia.
Thanks, Gemma. So the Advertising Code of Ethics in Australia is published by the Australian Association of National Advisors, or the AANA for short. Whilst it's not necessarily unlawful to breach the Code of Ethics, a breach of the code can result in a complaint being made to ad standards, which can lead to other consequences, such as the business being required to pull their advertising. Ad standards can also refer certain advertising to other regulators, such as the ACCC, who can issue penalties. So we won't go through the full Code of Ethics today. However, there are a couple of requirements that businesses should be aware of, and these apply to all forms of advertising, including social media posts. So some of the key guidelines of the code include, firstly, that advertising cannot portray people or depict material in a way which discriminates against or vilifies a person or section of the community on account of race, ethnicity, nationality, gender, age, sexual orientation, religion, disability, mental illness, or political belief. For example, advertisements containing the following messages will likely be in breach of the code. Suggestions that men who defer to their partner should be ridiculed or thought less of. Suggestions that men make purchasing decisions based on the attractiveness of a salesperson. Referencing a negative gender stereotype, such as women talking too much or women being less capable than men. Humorous references to how another culture is different, such as their name sounding different. And all of these examples are by reference to decisions of the Ad Standards Board in relation to real advertisements that were in the market. The second part of the code we'll talk about is that advertising shall not present or portray violence unless it is justifiable in the context of the product or service advertised. So for example, violence is not justifiable when promoting an unrelated product or service. Any malicious threat of violence towards a partner, even if it's just in a fantasy situation, is unacceptable. However, light-hearted banter or disagreements between couples in safe and loving relationships where the tone is not threatening or aggressive will not breach the code. Again, these are all related to decisions of the Ad Standard Board in relation to real advertisements. The final part of the code that we'll talk about today is that advertising shall not depict material contrary to prevailing community standards on health and safety. We often see issues relating to this standard when images of cars and drivers are included in marketing. So, for example, images can potentially breach the code if they show a person who appears to be driving, that is, for example, not holding the steering wheel properly, not wearing a seatbelt, not looking at the road, or touching a mobile phone. Also, images that depict young children in the car without a suitable seat or restraint will also likely breach the code. Some other more obvious examples of advertising that might be in breach of this standard include advertising that depicts people or even cartoon characters consuming drugs, advertising that shows cigarettes or smoking paraphernalia in a positive light, as this will be seen to glamorize smoking, advertising showing a person using a mobile phone at a petrol station. I'll now hand over to Gemma to talk about promoting your business using customer reviews.
Thanks, Amelia. So there's no doubt that promoting your business using customer reviews and testimonials is a great marketing strategy. However, it's important when doing so to be aware of a few of the following things. When looking at websites that are owned by a business, whilst businesses have control over what to publish on their own websites, they should do so in compliance with the law. So returning to Section 9 of the Australian Consumer Law, we know that it specifically prohibits fake testimonials and also false and misleading representations relating to a testimonial made by any person. So by publishing reviews that are fake or misleading, a business will breach the law. With this in mind, some key guidelines for including reviews on a business's own website include that the review should be genuine and the consumer should have actually used the product before giving the review. The review should not include any inaccurate or incorrect descriptions of the product or service. The review should not amount to an endorsement of the product, being, for example, statements as to specific product features or claims as to performance. Statements such as, "I like the design" or "it was easy to use" are fine. The review should be unedited. For example, a review giving pros and cons of a product should not be edited to only show the pros, as this will be a breach of the law. If the review contains statements that you know to be untrue or potentially misleading to consumers, the review should not be used at all. As a general rule, if the review includes statements that a business would not be comfortable in using in any other form of advertising, it shouldn't be used. So turning now to social media. If you decide, like many other businesses, to use social media channels to promote your business, you're likely enabling public comments, and there is an overriding obligation to ensure that all content is accurate, irrespective of who put it there. So a business should monitor its social media pages and remove any posts that may be false, misleading, or deceptive to consumers. Any such reviews should be removed as soon as possible to avoid breaching the law. It's not recommended that a business reply to the post, as this may not correct the misleading impression. It's much safer to just remove it. Of note, larger businesses and businesses that have substantial followers are expected to devote more resources to monitoring their social media than, say, a small business or a business that doesn't have very many followers on social media. In terms of repercussions, the ACCC can require businesses to substantiate any claims on their social media pages, again, irrespective of who put it there, and can take court action where it identifies a breach of the law or issue infringement notice in certain circumstances. Added to this, third parties may bring a claim for damages for loss suffered as a result of false or misleading reviews published, and this can be brought by either consumers or competitor businesses. Okay, so moving on, I'm now going to talk a little bit about offering incentives. So offering incentives creates a risk that a person is not providing a genuine, unbiased review of your product. Businesses that offer incentives for positive reviews risk misleading consumers and breaching the law. Incentives should only be offered in exchange for reviews of your business, its products or services, if they are offered equally to consumers likely to give positive reviews and those likely to give negative. And these reviews are treated the same. Also, the reviewer should be expressly told that the incentive is available to them whether their review is positive or negative. It will be a breach of the law to use reviews by someone paid to write the review who has not actually reviewed the product, someone who's used the product but written an inflated review to receive a financial or non-financial benefit. Bear in mind, it will also be a potential breach of the law to only use positive reviews if the overall feedback is negative across all the reviews that your business has received, as that will lead to a false representation being made. In addition to consumer reviews, businesses are now engaging influencers to promote and review their products, which brings us to our next topic. Over to you, Amelia.
So as we would all know, today we live in the world of social media, and most of the advertising we see these days is through our social pipes and often through the use of influencers. But businesses still need to be very careful when using influencers to advertise their products. Businesses should be aware that using an influencer to promote a product or service is not a workaround for any of the requirements we've already talked about in this webinar. That's to say, a business can still be found to have breached the law if an influencer they've engaged to promote their product does so by posting content which is likely to mislead consumers. This is because the business can still be found to have had a reasonable degree of control over the promotion, even if they did not necessarily have creative control over that specific post. So when you're engaging influencers to market your products, these are some of the things that you need to be aware of. So as with customer reviews, it'll be a breach of the law to use an influencer giving a review who was paid to write the review but who has not used the product, or who has used the product but they've written an inflated review to receive a financial or non-financial benefit. Importantly, there is an overriding obligation on influencers to disclose that a post is sponsored. This disclosure should feature prominently on the post, and a failure to do so will be a breach of the Australian consumer law. So to satisfy this requirement, we'll often see influencers using the hashtags #ad or #sponsored, or you might see paid partnership on the actual post. An influencer doesn't need to be paid in money for a post to be considered sponsored. So sometimes we'll see that businesses are giving free products to influencers, and so this would technically be considered sponsorship, therefore requiring the influencer to disclose that a post is paid. Further guidance on what constitutes adequate disclosure can be found in the Australian Influencer Marketing Council Influencer Marketing Code of Practice that was published in 2020, which we'll just call the Influencer Code. We also know that most platforms, for example, Instagram, have their own terms and conditions in relation to sponsored advertising, which influencers and businesses should be aware of. Another thing to keep in mind when using influencers is that influencers in certain spaces must not provide advice. This is particularly the case when advertising financial products. So for example, a finfluencer, that's an influencer advertising financial products, can share factual information that describes the features or terms and conditions of a financial product. However, if a finfluencer shares this factual information in a way that conveys a recommendation that someone should or should not invest in that product, that could be considered giving unlicensed financial product advice, and that would be unlawful. And as we've already touched upon, the ACCC has a wide range of enforcement powers in this regard. As with any business engagement, it's always a good idea for businesses to have a written agreement in place with influencers, which sets out the terms and conditions of their engagement for sponsored posts. This will help businesses avoid any uncertainty as to the terms of engagement, and will also help ensure that the influencer is aware of their obligations. In particular, firstly, their duty of disclosure, and secondly, the requirement that they actually use the product or service. These agreements should also clearly set out that any post should be genuine reviews of the product and not include inflated or incorrect claims that are likely to mislead consumers. Using formal agreements can really help businesses put clear boundaries in place. For example, it can help prevent an influencer from making a comparative claim with other products, which might be a risk for the business. The influencer code also recommends formal written agreements be entered into, and that code also suggests that these following terms be included in the agreements. So terms relating to intellectual property rights, which would address the creation, moderation, and review of the post. Reputation and brand safety, which addresses what disclosure might be required by the influencer prior to an engagement with a business. Legal or other industry code compliance. For example, if the post relates to alcohol, then there's certain alcohol advertising requirements which should be addressed. And of course, remuneration. As a way of minimizing risk, we always suggest that a term be included in the contract that draft videos be reviewed by the business prior to being posted, so that the business can consider whether there are any potentially misleading statements or images. In addition to what we've discussed today, if you're sending advertising by direct mail, you'll need to be aware of the Spam Act. We've included a link here to a fact sheet which you might find helpful in relation to this, and you can download it via the handout section on your screen. You might also find our next event of interest, which is called Playing for the Prize, How to Run Trade Promotions. This is taking place next Thursday at 11 a.m. and you can register via the link there on the slide.
Thanks, Amelia. Okay, now I think we're going to have some time for some questions. We've already had, sorry, I'm just having a look now. So the first question, I'll take this one. So the question is, sometimes businesses fake or use friends, family for a good review to sweeten the business image. Is this breaking the law? So the short answer to this one is yes, because this would not be a genuine review and it would actually be worse if they hadn't used the product. So again, you can't have any fake reviews. If your family and friends had used the product and services and posted a genuine review, in some circumstances, this would potentially be acceptable depending on the type of product. Again, businesses have an obligation not to create an overall misleading impression. So by only posting family and friend reviews, this may still be a breach of the law. There may also be additional regulations that apply depending on the type of product it is that the business is promoting. For example, the Therapeutic Goods Advertising Code 2021 that prohibits reviews by immediate family unless this is disclosed in the advertisement. So it would have to say the person's name is a brother, cousin, sister of, the business that they're promoting, which I'm assuming most businesses wouldn't really want to include in their reviews. Okay, next question. Amelia might give you this one. How do the new Therapeutic Goods Act advertising code and current AANA code of ethics regulate the influencers advertising by any medium?
Yes, so the TGA advertising code has been all over the press recently. It includes a number of requirements in relation to advertising products that are listed on the Australian Register of Therapeutic Goods, so the ARTG for short. We could probably do a whole seminar on all of these requirements as it's quite extensive, though we have actually covered some of them already. So, for example, not including misleading claims in advertising. In addition to that, though, the TGA code includes a number of mandatory statements that promoters of ARTG listed goods have to include. So, for example, if the promotion is for a good that's only available from a pharmacist, the advertisement will need to include ask your pharmacist about this product in the advertisement itself. So, and there's a number of other mandatory statements for certain circumstances. And in addition, one of the requirements that's been given a lot of media coverage recently is that testimonials can't be made in relation to advertising ARTG listed products where the person giving the testimonial has received an incentive. And remember that an incentive doesn't necessarily have to be money. So if an influencer, for example, has been given a product that's ARTG listed, they're not allowed to actually do an advertisement about that. Though if they just happen to have a product that they'd purchased themselves that they really love, then they could definitely do a post about that, as long as it wasn't paid. Hopefully that answers that one, Gemma.
Thanks, Millie. So I've got another one here that's just come through that says, what about reviews? Does that include someone reviewing a book? So that's still a product and service, so it's still covered by the Australian consumer law. So it would just, everything that we talked about in the seminar today would still apply. Millie, I've got a question here. If I have a customer using a product for free, is their review allowed?
Yes, so their review will be allowed as long as it's genuine and that they've actually used the product. But as we mentioned, if that's if an influencer is doing this, then they'll have to disclose that it's essentially a paid promotion because the product's been given for free.
Yeah. Someone's come through and asked, if we need to remove negative comments, how does that fit with needing to publish all the reviews without editing? So I think just to clarify that, so you don't remove negative comments, you remove all comments that include misleading or incorrect statements or statements that you know to be untrue about your product. So it's not negative reviews, it's reviews that are potentially in breach of the law. Just let me have a look. Next question. Okay, Millie, this one's for you. What about if I want to compare my product to another product?
So comparative advertising is something that we get very nervous about when we see it. It's a direct challenge to competitors. So if you are going to use comparative advertising, you need to consider whether the comparison is accurate, whether the products and services being compared are reasonably similar, and whether the comparison will be valid for the life of the promotion. So if this was included on a website, it would need to be removed if something changed with the product or something like that. Comparative advertising can expose businesses to real risk of action being brought against competitors for obvious reasons. So you have to be very, very careful about using comparisons in the advertising, and we always think it's really important to get advice on that before you run any ads, so that the exact comparison can be looked at in context, and you can have someone assess how high risk that might be.
Thanks for that one, Millie. Okay, next question. What if a business is making exaggerated claims on that website? Will that be misleading and deceptive conduct? So there's a difference between misleading claims and sort of overly exaggerated claims, which is what's called puffery. So an example of what puffery is sort of saying, we've got the best pizza in the universe, or sort of using big fluff words to try and, over exaggerate how good your product is, as long as it's not in relation to the specific, like how the product works and things. Sort of those sorts of claims aren't misleading because it's clear to the consumer that it's an exaggerated claim. So if you're going to make those sorts of claims, make them as sort of out of this world as you can, because then it's obvious that it's not a real claim. That would probably be the best way forward with those.
That probably ties into another question, Gemma, that we've received about brands posting meme-style reviews that are obviously fake, but still speak to the benefit of the product or service. So I think, again, that would really be contextual, but it's possible that something like that might be considered puffery, so might be appropriate. But again, it's all about the overall impression. So you just need to be really careful that the review remains accurate, rather than giving away anything that might be misleading. But often those sorts of exaggerated reviews can just be considered puffery, which is acceptable.
Yeah, I agree, Amelia. It is really just in the context of each ad. I mean, each one has to be considered the overall impression. When you're looking at it individually, there isn't, unfortunately, a one-size-fits-all when it comes to these sorts of adverts. You really have to look at all of the images, the wording, and everything in context together. Just having a look for more questions. So there's a question here, if the product review is given by employees who have used the product, is that considered customer review or marketing efforts by the business? So again, just at a high level in relation to this, I think, especially for therapeutic goods, employees can't give these reviews. They're not independent reviews or genuine reviews of the product. So we would recommend not having anyone related to the business providing those sorts of reviews on your websites.
There's another question which says, is it acceptable if with your product you add in a business card that states, tag us in your photos and leave a review for an instant 20% off your next purchase? So that would go back to that incentives can be offered in certain circumstances, but they have to be equal. So you couldn't offer an incentive for a good review, but you could offer an incentive for a review as long as that it was treated equally, whether it was a positive or a negative review.
Yeah, and I think if you're going to be offering sort of pricing incentives like that in relation to your business card, any sort of terms and conditions about, for example, where it has to be spent would need to sort of be clearly stated, I think, at the outset. Okay. So, Millie, this is one for you. What are some of the rules around marketing alcohol products?
Yeah, so there are lots of different more specific rules around marketing of certain products, so marketing alcohol or marketing products to children, for example. So in relation to alcohol, there is a responsible alcohol marketing code, which sets out a very extensive list of rules around marketing alcohol. So we won't go through them all, but for example, some of the rules include that marketing of alcohol products can't show or encourage the excessive or rapid consumption of an alcoholic beverage. They can't encourage irresponsible or offensive behaviour related to the consumption of alcohol. They can't encourage the choice of a particular alcoholic beverage by emphasising its alcohol strength, though, of course, if it's a lower alcohol strength, that there are different considerations there. You can point out that it's a lower strength, say a mid-strength beer or something like that. Marketing of alcohol can't have a strong or evident appeal to minors. And for example, you couldn't show alcohol consumption as contributing to certain achievements such as business, sporting, social, or other successes. So, I mean, there are a number of other things to point out, but those are just sort of some of the main ones to think about. But it is all included in the Responsible Alcohol Marketing Code.
Thanks, Millie. Someone's come through and asked, can you give some more detail about endorsements against reviews or versus reviews? So reviews are obviously, I found the product really easy to use. It was really streamlined. You know, the things that you liked about the product, or, you know, you can say it's good value for money, but you shouldn't sort of say it cost me this much. But in terms of endorsements are more like when someone's saying specific benefits about the product. It says, you know, it has a battery life of 4 hours and it has, you know, 7 features and 3 speeds and all that sort of thing. So an endorsement's more about sort of touting the specific benefits of the product, but without really saying how they actually liked the product. So the reviews, these sorts of reviews are supposed to be why the person was happy that they purchased your product, essentially. So that would be the answer to that one. We've had another comment through here. Millie, I would probably get your views on it, but I'll just give you mine to start with. So what can we do if an influencer is demanding free products or they'll give us a bad review? So I think obviously if you're getting false or misleading reviews on your own website, you can obviously delete these. But I think if an influencer is posting bad reviews on Instagram, for example, Instagram's got its own terms and conditions of use. And so you probably just report it to them in the first instance, because obviously the influencers spend a lot of time you know, gaining their followers and sort of getting up their marketing through these social media platforms. And so for them to have their account frozen or closed down would obviously be a repercussion for them. But Millie, did you have any other thoughts on that one?
Yeah, I mean, if a person has a reason to give you a bad review which doesn't relate at all to your business or is false, then there are other things that you could look at in terms of defamation or other sorts of claims like that you could make. So if someone is publicly posting something about your business that is obviously false and it's perhaps been published with some type of malicious intent, then there are other areas of the law that you can consider. You know, you can rely on certain defamation legislation to issue them with some type of letter which requires them to pull it down, all those sorts of things. So I mean, that's a sort of separate issue to advertising, but there are definitely steps that businesses can take if they're sort of receiving these types of obviously incorrect and malicious kind of reviews. There's another question here, Gemma, about are there certain bodies that take care of monitoring and enforcing compliance? For example, the ACCC or ASIC for financial advertising. So, I mean, yes, there are. So I think we touched on the Ad Standards Board. So what they do is they take complaints from people who have perhaps seen some advertising that they weren't happy with, and they investigate that, and they can take certain actions, such as requiring businesses to pull down that advertising. And if they don't, there are other repercussions. They can also refer advertising to the ACCC. So the ACCC is the enforcer of the consumer law. So they'll be looking at misleading statements and all those sorts of things in advertising. ASIC also has powers over financial advertising. So as we mentioned, ASIC has certain guidance about advertising in financial services, and then they have enforcement powers in relation to that space as well. So yeah, and if the ACCC was to take action, you'd probably be looking at the issuing of a penalty perhaps. They may, at the first instance, require that a business substantiates any claims made in their advertising. In the worst case, they can take legal action against you in the courts as well. So hopefully that sort of helps out with that question.
Okay, thanks, Millie. I think that's all the questions we've got time for today. Millie, if you would like to talk to everyone about membership.
Yes, so LegalVision offers a fantastic membership product, which can give you access to unlimited document drafting and reviews, unlimited legal advice consultations with our team of lawyers who are from all different areas of expertise, unlimited Australia and New Zealand trademark applications and other benefits. The membership is offered as an affordable monthly fee for cost certainty. So it's a really, it's amazing offering for businesses. And we also have a desk extension product for high volume advertising needs. So if this is something that might interest you, please reach out to us and we can give you some more information about that. Also today, all of our webinar attendees are eligible to receive a complimentary consultation with us to discuss how we can help you with your business needs or your advertising compliance obligations. So to book this complimentary consultation, please just leave your contact details in the survey that will appear after the webinar ends and we'll be in touch. Alternatively, you can email the email address on the screen there and mention that you watched this webinar and we will come back to you. So thank you. That is all for today, and thanks very much for joining us. I hope that was helpful.
Thanks, everyone.